Members, it's the appointed time. Welcome to the meeting of the panel on the administration of justice and legal services. Some items on the agenda for today. First, information paper issued since the last meeting. No such paper. Second item on the agenda, items for discussion at the next meeting. I believe members have received else paper CB bracket 4446/2023/01. That's the list of outstanding items for discussion. On June 26th, that's a Monday at 4:30 p.m., we will have the next regular meeting. We will discuss the two items proposed by the government. First, mainland and overseas visits conducted by the Department of Justice in the first half of 2023. And second, briefing on initiatives of the Department of Justice to promote the rule of law on all fronts. So, members, any comments on those proposals? If not, we will proceed to discuss those two items at the next regular meeting. A reminder to members, on June 2nd, that's a Friday at 10 a.m., we will visit the High Court. We will meet with Mr. Andrew Cheung, the Chief Justice, and also Mr. Jeremy Poon, Chief Judge of the High Court. And then we will have lunch together. The Secretariat will let members who have signed up know the details of the visit. Any comments on this arrangement? If there are no comments, let's move on to the third item, proposal to amend the Criminal Procedure Ordinance Cap 221. You should have three papers by now. First, CB bracket 4446/2023/02. That's the government's paper. And also CB bracket 4457/2023/01. That's the submission from the Law Society of Hong Kong. The third paper is CB bracket 4481/2023/01. That's the government's reply to the submission from the Law Society of Hong Kong. In fact, there is a fourth paper. That's the submission from the Hong Kong Bar Association. That paper has been tabled. Let's welcome Mr. Paul Lam, Secretary for Justice, and his team. We also welcome representatives from the Hong Kong Bar Association and the Law Society of Hong Kong. Members who would like to speak, please press the button now. Before you speak, we will have Mr. Paul Lam walk us through the government's paper. Thank you, Chairman. The Department of Justice proposes to amend the Criminal Procedure Ordinance, that's Cap 221 of the laws of Hong Kong. We want to set up a statutory procedure for the prosecution to appeal by way of case stated against a verdict or order of acquittal given by the Court of First Instance constituted by a panel of 3 judges for cases endangering national security under Article 46 of the National Security Law. Let me first point out that we have a duty under the National Security Law. We have to keep improving our legislative systems for safeguarding national security. We have to effectively prevent, suppress, and impose punishments for acts and activities endangering national security. The SAR government has been reviewing our existing laws. Once we spot laws that fall short of this requirement to safeguard national security, there's a need to amend and improve the laws in a timely manner. We have to make use of local laws to resolve the legal issues as we safeguard national security. In this context, the Department of Justice has reviewed the criminal justice system in relation to the national security law. There's room for improvement when it comes to appeal. Now, there are 2 kinds of trials at the Court of First Instance, or CFI. First, we can have a case before a judge and a jury, or alternatively, when the Secretary for Justice issues a certificate under Article 46 of the National Security Law, you can have a trial before a panel of 3 judges without a jury. These 2 modes of trial are different in one way. When you have a jury, the jury does not have to provide the reasons for the decision, whereas when you have a panel of 3 judges, they have to set out the reasons. With the district court and the magistrates court, the prosecution, the defense, and also the public will get to know, and they will get to see the analysis of the evidence and the laws, and they will see findings of fact and rulings of law. Whichever trial it is, the defendant can appeal against the conviction and the sentencing. At the magistrates court and the district court, when you have a criminal trial, when the judge or magistrate gives an acquittal, but the ruling shows an error in law under the existing district court ordinance and the magistrate's ordinance, the prosecution can appeal against the acquittal by way of case stated. But then, when you have a panel of 3 judges at the court of first instance trying a case involving national security and there's an acquittal, the existing law does not allow the prosecution to appeal against the acquittal to the court of appeal. This is an anomaly. Giving an acquittal to a guilty party is a miscarriage of justice, and that's just as bad as convicting an innocent party. A wrongful acquittal may lead to very grave consequences. To deliver justice and also make sure that the judiciary can discharge their duties under the national security law, that is effectively preventing, suppressing, and imposing punishments for acts and activities endanger national security, there's a need to empower the prosecution to appeal and give and allow the court of appeal to fix errors of law, and this means reversing wrongful acquittals handed down by the court of first instance. I will go through the highlights of the proposal. First, a mechanism for appeals through by way of case data. This is modeled on Section 84 of the District Court Ordinance and also Section 105 of the Magistrates Ordinance. The new provisions will be of a procedural nature. They will apply to rulings, that is, acquittals, or either as a verdict or order after the bill takes effect. The new provisions will not apply to jury trials, whether those cases have to do with national security or not. The appeal will be about questions of law only. Errors in law include findings that no reasonable judge, having looked at all the facts and directed themselves correctly, would never have come to, that is, perverse findings of fact. After the prosecution appeals against the acquittal, we need to keep the status quo so that the appeal does not become nugatory. So we propose to empower the trial court and the court of appeal to detain the respondent or admit the respondent to bail. Now, if the court of appeal is satisfied there are sufficient grounds for interfering with the acquittal, then it must reverse the acquittal. It can either direct a retrial or the trial be resumed or dismiss the appeal. The Court of Appeal can also make all other necessary consequential directions. The Department of Justice has consulted the stakeholders in the legal profession, including the 2 legal professional bodies and the law schools. With the replies that have come back, they generally support the proposal. In Annex B, we have set out all the points, the comments on the procedural and the lead points of law. I do not propose to go over them again. Simply put, we need to create a sophisticated, well-developed, and fair criminal justice system that's key to our rule of law. To maintain our unique advantages of our common law system, we need to make sure that our common law system, including our criminal justice system, keeps pace with the time to ensure justice is delivered. And the proposal has no adverse implications for the independent judicial powers of the judiciary, and this does not contravene the principle against double jeopardy. the government proposes to submit this proposal along with the proposal to deal with no case to answer appeals. Another, that is a proposal regarding appeals against criminal trials involving no case to answer cases. These two proposals propose to address gaps in the legal system. One of them has to do with national security. So there's a duty on the government to fix the problem in a timely manner. After listening to the stakeholders, the government will submit the bills to the Legislative Council. We welcome comments from members and the chairman, and we're happy to take any relevant questions. Thank you, Chairman. Thank you, Mr. Lam. From the Bar Association, the Department of Justice has proposed to amend the Criminal Procedure Ordinance. We have provided our written submission. This is also reflected in our submission to the Legislative Council, and there are also replies from the DOJ. We will not go over them again. Just 2 points I would like to make here. Under common law principles, at other common law jurisdictions, there are rather limited options for prosecution to lodge appeals, but there is a growing trend where changes are happening. So for prosecution-initiated appeals against acquittal, it's not something unique to Hong Kong. This is something I would like the public to know. Now, another point of interest to people of the legal profession, it's about bail. You know that under the national security law, there's a high threshold for granting bail. Some in the legal profession may be wondering, you have 3 judges giving an acquittal for the defendant, and comes the appeal, should the bail be granted? Some wonder this may be unfair to the respondent or the defendant. So we would like the Department of Justice to consider to see if there are ways to safeguard the rights of the defendant or the respondent. Thank you. I thank you for the comment. Now over to Mr. Christopher Yu from the Law Society of Hong Kong. First of all, on behalf of the Law Society, I thank the Department of Justice for listening to the views from the legal profession on this proposal. We provided written submissions. At the District Court and the Magistrates Court, the prosecution can appeal against an acquittal by way of case stated to a superior court. The existing law does not allow the DOJ to appeal against an acquittal when it's a panel under Article 46 of the National Security Law, even if there is an error in law and the DOJ cannot appeal against that by way of case stated. We think that's not ideal. That's a loophole in the system. So we agree there's a need to amend the law to plug the loophole. So we support the DOJ's proposal. We don't get to see the bill yet. So we hope in the future, when the bill is available, it will be consistent with what's there in the District Court Ordinance and the Magistrates Ordinance, and we look forward to reading the bill. Next, Mr. Stephen Hong, anything to add from you? Nothing. So now I open the floor to questions from members. 5 minutes for each member. 3 members have pressed the button: Ms. Carmen Khan, Ms. Eunice Yung, and Mr. Dennis Leung. Over to Ms. Carmen Khan first.
Thank you, Chair. I speak in support of this proposal to amend the Criminal Procedure Ordinance. As mentioned by the Secretary for Justice, in national security cases, if a panel formed by 3 judges make an acquittal order and the and there is an error of law in the ruling, there is inconsistency between the district court level and the magistrates court as well as the high court level. If there is such procedure in district court and the magistrates court at the present, how come there isn't such arrangement in the high court? There are more of such prosecution appeals or venues for such prosecutions in other jurisdictions at different levels of courts. So how come we should not have an alignment of this arrangement at the high court level? Also, I have a question about an error of law. Can you give an example of such error? If a judge have a misunderstanding of the elements of the 4 offenses under the national security law, is that equivalent to an error of law? And can appeals be made in this case? Also, as we in February had a discussion in relation to the no case to answer proposal, for ordinary cases that is not national security cases, we will also implement the no case to answer appeal proposal when we introduce the legislative proposals or legislative amendment. The Hong Kong Bar Association just now mentioned about the high threshold in granting bail for national security cases. In national security cases, if panel of the Court of First Instance makes an error of law, I think we should stick to the threshold in granting bail for national security cases, even for all other ordinary cases. There's a question and a suggestion. I wonder if you have any response to the suggestion. Thank you, Ms. Khan, for giving me a chance to explain what it means by an error of law. It's hard to give an exhaustive list, but to give an example, like what Ms. Khan said, say under the provisions of national security law, there are certain elements to an offense that constitutes an offense under the national security law. If there is a misunderstanding, then that is an error of law. Also, we have to consider whether we can accept certain evidence. There are, for instance, hearsay evidence. When the court decides whether an evidence has to be accepted or should be accepted, and there is a wrong finding, then that also constitutes an error of law. An error of law should not have anything to do with factual findings. If a judge or a reasonable judge has already properly directed himself, and no reasonable judge would come to a conclusion like this judge involved would do, or come up with a perverse conclusion, then this is an error of law. So this is an example that I am giving in terms of what constitutes an error of law under the existing legislations. I've heard the views of Hong Kong Bar Association as well as that of Ms. Carmen Khan. On the question of bail, as mentioned in the submission of the Bar Association, the standard of whether a judge should admit the defendant to bail is that the status quo of the defendant should be preserved in national security cases. if the question of bail is bound by Article 42 of the National Security Law, whether a court should allow a defendant to be bailed or whether the defendant should be detained, I think we should adopt the same standard pursuant to Article 42 of the National Security Law. You mentioned about factual findings. This is not something new. It's all along been stipulated under the existing legislation. So it encompasses factual findings of a judge. Correct. Next, Ms. Eunice Yong. I speak in support of the proposal made by DOJ, that is to allow prosecution to appeal by way of case stated against a verdict or order of acquittal given by the Court of First Instance constituted by a panel of 3 judges to try a case concerning offenses endangering national security without a jury. I think this can plug the loophole and also address any miscarriages of justice, and this is a reasonable proposal. According to paragraph 18 of the government's paper, with reference to Section 84 of the DCO, the government is proposing the following actions in determining an appeal. As we all know, the Court of Appeal will not unreasonably interfere with a verdict. I want to understand from the DOJ's point of view, normally, how will the Court of Appeal decide whether to order a trial be resumed or whether the respondent should be retried? What criteria will the Court of Appeal take into consideration when making such decision? Even if the Court of Appeal finds that the panel makes an error of law, it doesn't necessarily mean that the Court of Appeal should or must interfere with the acquittal. SJ. The proposal is to empower the Court of Appeal to exercise its discretion. In each case, there are different reasons why a panel makes an error of law, so we have to look at it on a case-by-case basis. For example, if there is an error of law made by the panel and the Court of Appeal finds that there are reasons for the trial to be resumed, of course, that's the most efficient way to handle the case. It is time-consuming to form another jury, and this may affect the progress of the case. Say if an acquittal order is made and the jury has been disbanded, and it's practically not possible for the court to, for instance, resume the trial. Also, we have to take into consideration whether the original jury can objectively hear the case again. Or in other cases, if the error of law is insignificant and it will not affect the outcome of the case, then the Court of Appeal can exercise discretion and make the order not to resume the trial or not to interfere with the order. So we have to look at the nature of each case to make a decision. I'm referring to cases without jury only. So we have to look at the nature of the error of law made by the panel, because it will affect whether the trial should be resumed. The example I made about the jury may not be very appropriate. I want to correct myself. We have to basically look at the nature of the error of law and also the entire case. Other considerations should be taken into account as well. For instance, if a jury does not make an error of law, or had the jury not made this law, or had the panel not made this law, this error of law, then the lower court should convict the defendant. Under the existing arrangement, the Court of Appeal can order the lower court to make a conviction and pass a sentence in its own right. So I want to point out that there are various options for such cases or such situations to be handled. I have a follow-up question. Even without jury, the principle for the court of order to adhere to as it decides whether the trial be resumed should stay the same? Yes. We're only talking about a panel without jury in trying national security cases in this proposal. So we have to look at the nature of the error of law. So to respond to your question, the answer is affirmative. Next, Mr. Dennis Leung. Thank you, Chair. I give my support to this legislative amendment proposal, as we have to effectively prevent, suppress, and impose punishment for acts and activities endangering national security, and this proposal can help us improve the system. I'm not a legal professional. As a citizen myself, I think that when the national security law comes into effect, there are instances where prosecutions are not allowed to appeal by way of case stated. If a defendant is guilty and the court rules that the defendant is guilty, then there will be no questions or problems. But if the defendant is guilty and a verdict of acquittal is made, then there are a lot of uncertainties revolving around such cases, which makes it hard for citizens to understand. Whether this proposal or the current arrangement is in conflict with the Basic Law or the Hong Kong Bill of Rights, there are questions or doubts as well. So I support this legislative amendment proposal so that we can ensure openness, fairness, and impartiality of our judicial system. I think with this proposal, the government should make clear to the public the advantages of implementing this proposal so that the citizens can have a better understanding of why we need to introduce this proposal. SJ? For those not in the legal profession, I think we have to make more explanations to them. I promise that we will do more to explain to the public this proposal. I thank the two legal organizations for helping to explain this proposal as well. I have a question myself as well. In normal criminal cases, in the current mechanism, there are restrictions as to prosecution appeals. We understand that there have been changes internationally. I believe that you're referring to criminal trials rulings or verdicts. For national security cases, what are the current practices in other countries in terms of their appeal mechanisms? If prosecution is not given a chance to appeal in national security cases, I would be surprised. So I want to know the current practices in other countries.
If you don't have the figures at hand, you can give us the figures after the meeting. We have looked at the practices elsewhere. We don't see anything particularly different. We are not aware of any overseas practice where the prosecution cannot appeal against an acquittal. Overseas, on prosecution-initiated appeals, they are in line with ordinary criminal appeals. Just as the chairman of the Bar Association was saying, across common law jurisdictions, there are now more mechanisms, reasonable mechanisms for the prosecution to appeal against acquittals arising from errors of law coming from the trial court. So this is in line with the practice elsewhere. Speaking for the second round, Ms. Eunice Young, 4 minutes. A question about paragraph 16. So when the appeal is pending, the status quo of the defendant/respondent will be kept. So this is modeled on Section 35 of the Court of Final Appeal Ordinance and also Section 84B of the District Court Ordinance. The government proposes to introduce the following provisions. Immediately after the panel gives a verdict or order of acquittal, the prosecution may inform the panel of its intention to appeal. So does the prosecution just let the court know? Will there be submissions or evidence or supplementary documents required? Will there have to be a formal application? So the panel can detain the defendant or admit the defendant to bail. Would this require a separate application? Or does it work like right after the ruling is handed down, the prosecution can go to the court, let them know about the intention to appeal? So does the prosecution go to the CFI or does it go to the Court of Appeal instead? So here's how it works. Right now, for national security cases, they can be tried by a panel of 3 judges. So after the 3 judges decide on the outcome, they have to give the reasons for the verdict and then give the verdict. Say you have an acquittal, so we know what the reasons are. At that point, if the prosecutor thinks there are problems with the acquittal, then the prosecutor tells the CFI about the intention to appeal. There are 14 days for the prosecution to prepare the formal application by way of case stated. So there will be a 14-day window for the prosecution to file the application. But then within that 14-day window, we need to keep the status quo. So after the prosecution tells the court about the intention to appeal, and then the prosecution will raise the points about whether there's a need to detain the defendant/respondent. And then after the lapse of the 14-day window, the prosecution will come to a decision on whether to go ahead with the appeal, and then the court will decide what to do next. Say after 14 days, we looked at the judgment, and we don't see enough grounds for an appeal, then the defendant will be acquitted, and there will be no further reason to detain the defendant. But if we do decide to go ahead with the appeal, then the court looks at the condition and decide what to do with the defendant. Simply put, the intention to appeal will be made known to the court of first instance, that is the trial court. And then we keep the status quo within the 14-day period. That's to make sure the intention to appeal or the appeal does not become an academic exercise. Because we need a mechanism to make sure that the court can impose reasonable restrictions on the defendant. Otherwise, we decide we need to appeal, but then the defendant is already gone. Then the appeal process becomes nugatory. Chairman, I'm worried we're talking about cases involving national security. So if you have a gap before the hearing, will there be a loophole? Of course, the defendant may be acquitted at first, but if there's a glaring area of law and the defendant is not locked up right away, will there be a loophole? Will there be a risk that this defendant can abscond and go overseas and then we cannot convict that defendant? Now, that's exactly why we propose this provision. Now, we apply the principle of Article 42 of the National Security Law. Unless the court is satisfied that this defendant will not continue to engage in acts endangering national security, bail will not be granted. The court decides whether there will be detention or whether there will be bail for the defendant under the principle under Article 42 of the National Security Law. We exactly want to deal with the scenario raised by Ms. Yong. That's why we propose this provision. The prosecution can apply to the court if considered necessary, and even after the CFI acquits the defendant, we can propose and the court can decide to detain the defendant for the time being until the prosecution decides whether to proceed with the appeal. Ms. Carmen Khan speaking for the second round. I thank the DOJ for responding to the point about bail. This is exactly the point set out under paragraph 16C. On detention and bail, the principle under Article 42 of the National Security Law will apply. Now, the U.S. Executive Congressional Report on China released a report in May. 29 judges were on the list of that list, and then lawmakers there proposed sanctions on these national security judges. Our government condemned such a proposal because this is a despicable move. So can I get the Secretary for Justice tell us? Now, this proposal in relation to our judicial independence and the rights of defendant, this proposal will do nothing to harm the rights of the defendant. This proposal here is simply to address an anomaly. We're not making substantive changes with this legislative proposal. We need to stress this point. We're trying to fix errors of law. That's why I put that question to the DOJ on what an error of law meant. An error of law can lead to miscarriage of justice. So, is it the case that we will proceed with this move along with a change to deal with the no case to answer appeal proposal? So this will follow the practice of the Criminal Justice Act. Now, since we are dealing with an anomaly of the appeal concerning national security cases, so how will the framework work? Because the two lawyers' bodies told us that they will need to look at the bill before they can comment further. Ms. Khan is right to point out that we are proposing an appeal mechanism, and this mechanism will not affect the right to independent adjudication of Hong Kong's courts under the Basic Law. We are simply giving the prosecution the mechanism to appeal against something that's caused by an error of law. The Court of Appeal will go by their long-standing right of independent adjudication in deciding whether the lower court made the error of law. So the matter still rests in the hands of the court, as Ms. Carmen Khan rightly pointed out, and as the two legal professional bodies rightly pointed out. We are dealing with a gap, a loophole in the existing mechanism. The prosecution does not even get a chance to ask the Court of Appeal to look at whether the lower court made an error of law. Now, the second point. Our proposal has to do with two separate items. First, on acquittals. At another meeting of this panel, we talked about the no case to answer appeal proposal, that we will follow a British statute for that exercise. But then coming back here for acquittal by a panel of 3 judges on national security cases, we will model this change on the district court ordinance. So there will be 2 parts to the bill. In this exercise, we will have 2 discrete parts. After all, we're dealing with 2 separate matters. Different thought processes apply to these 2 changes. Now, we want to improve the laws as quickly as possible, so we put the 2 changes together into one amendment exercise, but there will be discrete parts dedicated to each change. Mr. Holden Chow. Chairman, a comment here. The paper has made this clear. An appeal by way of case stated is already found in the mechanisms for the district court and the magistrate court. But then this mechanism is non-existent for national security cases at the court of first instance. So we are simply trying to plug a loophole. We need to give the prosecution the right. We need to give the prosecution a mechanism where they can appeal against an acquittal. Say a trial judge makes an error of law and a wrongful acquittal results for defendants for national security offenses. That's a miscarriage of justice. Since an error of law may be involved, so we need a mechanism to fix that. So we're plugging a loophole. Going forward, can I get the Secretary for Justice to make this point clear to the public? For me and for the 2 legal professional bodies, we should explain this point to the public. Another point already raised by Ms. Carmen Khan. Now the CECC, the Congressional Executive Commission on China. I believe that's a despicable act because the U.S. is threatening the national security judges. Now, I know the Secretary for Justice has already condemned the move, and we should keep the situation in view. This kind of roguish attempt at undermining us will simply continue. I'm just trying to make a comment. Just a comment. Any response from the government? Other questions from members? If not, sorry, one last question for the Bar Association. Anything to add? We have already made a point, and also for Law Society, nothing. So let's move on to the next item on the agenda. The next item, updates on the implementation of the enhancement measures to the legal aid system. We have 2 papers. First, CB bracket 4446/2023 bracket 03, paper from the government. The other paper, CB bracket 4446/2023 bracket 04. This is the background brief prepared by the Legislative Council Secretariat. Let's invite the government officials to join us. welcome officials from the administration's office. Mr. Steve Wong from the Legal Aid Department. Mr. Chris Chong, Director of Legal Aid. And also from the Law Society of Hong Kong. We have a couple of representatives. First, we will hear from Ms. Eva Yam, Deputy Director of Administration, and Mr. Chris Chong from the Director of Legal Aid. Please walk us through the paper. Thank you, Chairman. Chairman, we want to update members on the enhancement measures to the legal aid system in place since October 2021. I will briefly go over some of the points, and then the Director of Legal Aid will tell us about the latest progress. The legal aid system is a key part of our legal system. It's key to safeguarding our rule of law. The government has been striking balance between safeguarding the rights of legally aided persons and public funds. This is to ensure reasonable access to legal services. In 2021, the government reviewed the legal aid system and proposed a range of enhancement measures. At that time, there was much attention to this issue about potential abuse by legally aided persons or APs. And then for criminal cases and judicial review cases, there was a concern that those cases were concentrated in a small number of lawyers. Through the review, the government also wanted to deepen understanding of legal aid and try to clear up misconceptions about the legal aid department. Since the measures were put in place, we are seeing if these measures are effective in preventing abuse of the legal aid system and preventing the over-concentration of legal aid cases in the hands of a small number of lawyers. So these measures mean a larger pool of lawyers who can take up legal aid cases to benefit APs. This also marks a positive step for the legal profession. I will now invite the Director of Legal Aid to tell us about the enhancement measures.
Thank you, Chair. In 2021, the government implemented the enhancement measures, and there are mainly three parts to the measures. Mainly, enhancing transparency, enhancing the management of legal aid applications, and also enlarging the pool of qualified lawyers. On case assignment, over the past 12 months, there is a reduced overall civil case assignment limit. The limits have been reduced from 35 to 30 for solicitors and 20 to 15 for counsels. The Legal Aid Department strictly maintained the number of cases to be taken up by solicitors and counsels. For civil cases, the number is 5 for solicitors and 10 for counsels. And there is a roster for lawyers taking up cases in the district court. We find that the average number of civil cases assigned to each panel lawyer has reduced. For instance, for each solicitor and each counsel, for the number of JR-related cases they take up, dropped from 7.5 and 3.2 to 4.2 and 2.6 respectively for solicitors and counsels. Also, for the top 10 solicitors and counsels handling legal aid cases, dropped from 41.8 and 27.2 to 30.1 and 21.4 respectively for solicitors and counsels, representing a drop of 25% or above. We see that these enhancement measures have reduce the overconcentration of cases among a number of lawyers. And in the long run, we are able to enlarge the pool of qualified lawyers taking up legal aid cases, and in the long run benefiting legally aided persons. On transparency, the legal aid department has come up with a more structured publicity communication plan, as well as a swifter response mechanism to clarify the department's stance and case details. The department also regularly released statistics for various types of cases on its homepage. And in relation to JR cases, we asked the applicants for legal aid to disclose the details where appropriate, including the results of their applications and the details or reasons why the legal aid applications are granted. We hope that these measures can help the public understand more about the work of the department, as well as dispel any misconceptions relating to the department. The department set up an internal monitoring committee for JR cases, and we regularly report to Legal Aid Services Council on our handling of JR applications and management of relevant approved cases where necessary. We also ask the lawyer who are assigned cases, if they are unavailable to represent the legally aided persons, they have to immediately report to our department and return any papers they had received to us. And if any of the panel lawyers fail to comply with this requirement, we will remove their names from the legal aid panel. That is, we won't assign any more legal aid cases to them. We also ask legally aided persons to declare alternative sources of funding, such as crowdfunding. If they receive such funding, they have to declare the funding to us. If they fail to comply with the requirement, we have the right to refuse their legal aid applications or discharge or revoke their legal aid certificates, and even refer the matter to the police for investigation. Members are invited to note the latest position of these enhancement measures, and the government will continue to monitor the effectiveness of the measures. If members have any suggestions or comments in relation to these enhancement measures, please raise them to us. Thank you. I'll now invite Mr. Yu from the Hong Kong Law Society to speak. I'll pass the floor to Mr. Hong. Please refer to LC paper. Of this item, paragraph 8. I think it's hard to accept the information set out here. In the last AJLS panel, I was in the meeting, and we agreed that legally it seems that Director of Legal Aid does not have to consider nominations of legally aided persons in criminal cases. Legally, you do not have to accept such nominations, but such arrangement has been in place for many years already. The department has been accepting such nominations for many years. In the last panel meeting, I mentioned that I hope that the legal aid department would not reject all nominations. And the answer or response I got at that time was that there will be a set of considerations to be adopted by the department, and that the department will continue to entertain any applications for nominations of lawyers by legally aided persons in criminal cases. But now I see from the paper that the percentage of criminal cases assigned to the panel lawyers by direct assignment by the department is 100%. Legally aided persons have a certain level of trust in the system, especially at the lower level courts. A legally aided person may not have the financial ability to engage a lawyer themselves, and they may want to nominate a panel lawyer to assist them, but I am caught by surprise by the information set out in paragraph 8 that the LAD is not entertaining such applications by legally aided persons. Starting from 2016, we have been seeing this biannual legal review, and we had a meeting once or twice every year, and I found such review meetings quite productive and helpful. But over the past 1 or 2 years, it seems like the government is not or no longer interested in discussing with the Law Society in relation to matters of legal aid cases. I hope that we can resume this meeting and have a discussion about the existing system. We haven't had such meeting for a while, and there may be a gap in terms of the remuneration for panel lawyers. It's not enough for you to just stick to the CPI when you consider the pay for panel lawyers, and this will deter new lawyers in joining the panel. I have 3 points to make. According to the statistical information provided by the department, from 2017 to 2022, the certificates approved by the legal department dropped from 8,809 in 2017 to 5,938 in 2022, representing a 32% drop. And in 2017, there were 18,944 applications of legal aid in 2017, and in 2022 there were 12,229 such applications, representing a drop of 35%. And this shows that there has been a drop in the application of legal aid services, and the pay or the asset limit for legal aid applications is set at $433,010. On distribution of cases, it seems that the legal aid department is imposing a guideline. When you distribute cases, we hope that you assign the cases to lawyers with relevant experience or expertise. Otherwise, it would be very unfair to the applicants. That's my view. Over the past 2 to 3 years, I see that the legal aid department has tried to step up monitoring of legal aid cases. I think the department has been doing a good job in this regard. we should communicate more and see how we can further improve the existing system. Thank you. 3 members have pressed the button to speak. Ms. Carmen Khan, Ms. Maggie Chan, and Ms. Holden Chow, and Ms. Doreen Kong.
5分鐘。
Ms. Carmen Khan speaking for the first round, 5 minutes. Thank you, Chairman. My question has to do with paragraph 8 of the paper. Just then, Mr. Stephen Hong from the Law Society made a comment. He would like to see the Legal Aid Department engage in further discussions with the legal professional bodies. So I would like a response from the administration wing. Well, the key sentence is in the last sentence in the paragraph. This measure plays a pivotal role in eliminating the public's misconception that nomination of lawyers for criminal cases is a statutory right of APs. So that's the line of thinking of the government. We need to clear up this misconception. We want access to justice. So an eligible person gets access to justice, but this is not the same as having a particular lawyer of the aided person's choice. So the government thinks this is the right approach. I think more explanation is needed on this point. So take the example of a magistrate's court. There's a duty lawyer scheme. The duty lawyer scheme is put in place to make sure the defendant has a chance to get access to justice. The defendant does not get to choose a particular lawyer. It just depends on which lawyer is there, which lawyer happens to be on duty. The principle of the duty lawyer service is like what we see here in paragraph 8, so there's no right to nomination. This is something the government should explain further. Now, there is a Judicial Review Monitoring Committee. The members of that departmental committee is made up of legal aid department officers. The judicial reviews are actions taken against the decisions of the executive branch. Now, of course, the legal aid department isn't the government. But when you have internal personnel from the legal aid department sit on the committee, will that be a way to make sure the body is independent enough? Will there be further steps to make it more independent? Now, another point. Applicants to legal aid will have to declare the sources of funding, including if they're getting money from crowdfunding. So has the department conducted any survey, and what's the outcome of any such investigation or surveys for the legal aid department? Now, on the question about the departmental JR monitoring committee, we have colleagues from our department keeping an eye on cases involving judicial reviews. I'm the chairman of that committee. We don't want to see cases involving judicial reviews concentrated in the hands of just a couple of lawyers. So we have this departmental committee keeping an eye on the situation. There's no need to involve someone outside the legal aid department to keep an eye on our work. Now, we keep an eye on the performance of panel lawyers. The committee is there to make sure we can step up the monitoring of cases going. So it's not like there's a need to get an outsider to sit on the committee and keep an eye on how it's going. Now, on the lawyers to be assigned for criminal lawyers, I thank Ms. Carmen Khan for her analogy. There's a distinction between our practice and the duty lawyer service. With the duty lawyer scheme, there's a roster. At the legal aid department, we have a mechanism. We look at the experience of each panel lawyer. We look at the case details. And then with our expertise, we appoint the most appropriate lawyer. So this is a distinction between our practice and the duty lawyer service. With criminal cases, we will continue our publicity efforts. It's different from civil cases. So people don't get to nominate their lawyer in a criminal case. I thank Ms. Carmen Khan for her suggestion. Now, paragraph 15 on the source of funding. The applicant will have to declare their source of funding during the approval process or after the approval process. If anything comes to light and we become aware that the applicant has other sources of funding, we can reassess this person's eligibility. If the applicant has gone beyond the asset limit, then we may ask the applicant to pay an extra share of the fee, or we can even discharge the legal aid certificate, or in the cases of false declarations or withholding of information, we can revoke the legal aid, we can recover the legal fees, and we can even refer the case to the police for investigations. Ms. Maggie Chen. Thank you, Chairman. Now, the enhancement measures were put in place in October 2021. I need to declare my interest. I'm a panel lawyer with the Legal Aid Department. The measures were put in place in 2021. I've heard from the legal profession, solicitors and barristers alike. They got the impression that the cases were no longer over-concentrated in the hands of a few lawyers. Other lawyers taking up the cases are experienced lawyers. So I do see improvement. So no more over-concentration of cases in a few lawyers. But then on transparency and application and case management, I have some questions on and also some suggestions. First question, paragraph 9 of the paper. We see some stats here. Now, for the lawyers getting, the top 10 lawyers getting most cases, we do see a drop in both civil and criminal cases. Do we have a further breakdown by civil and criminal cases? We should not be looking at just the number of cases assigned. We should be looking at the number of cases each lawyer works on. Now, sometimes you get an unfair situation. It takes a long time for the legal aid department to arrive at the lawyer's fees. And then the legal aid department fails to provide the legal aid certificate. The delays in the processing is unfair to lawyers. Now, on the transparency issue, some have told me in civil cases, in fact in both criminal and civil cases, but many in civil cases, members of the public are saying in civil cases, they want to nominate a lawyer. The legal aid department says the lawyer is ineligible or inexperienced or already has too many cases on their plate. So are there guidelines for applicants on how to nominate their lawyers? I get complaints like these every now and then. On case management and monitoring, does the legal aid department have mechanisms for spotting cases of champerty, potential champerty? Or does the LAD rely on reports and then refer the case to police. And then for criminal cases, a case is assigned to a lawyer. So will the lawyer be allowed to take a case, and would there be a declaration of interest? For questions for the Director of Legal Aid. I'll try to get to as many of her questions as I can. Now, on the quota, paragraph 9 sets out the numbers. Ms. Chen is looking for a breakdown. Under the existing quota system, over 12 months, lawyers can take up to 30 civil cases and 25 criminal cases. So in total, each lawyer can take up to 55 cases over the past 55 cases, civil plus criminal. We look at the past 12 months. But that may not tally with the cumulative caseload. A lawyer may have been working on legal aid cases over a long time. Some cases take years to resolve. So you may have 60 or 70 cases accumulated for a particular lawyer. But that will not affect the number of the cases the lawyer can take based on the case count over the past 12 months. On applicants picking the lawyers. Now, we put the interests of the aided person first in assigning a lawyer. We want to put the most competent lawyer on the case of each applicant. We have a mechanism. Say the lawyer may need a certain number of years of experience. In the past 3 years, this lawyer has to have handled a certain number of cases of similar nature, or factors on whether this lawyer has already gone beyond the case count. And we also have to look at whether this lawyer has performed poorly in a past case. We provide the advice to the applicant, and the applicant decides whether to nominate that lawyer. So we put the interests of the applicant first. So we're not trying to sway the applicant's choice. We want to make sure the lawyer meet all our requirements. And as for the other questions, I will ask the director to answer those questions in the second round. I need to be fair to the other members. If there are no second rounds, and please provide a written reply to Ms. Maggie Chan's questions. Mr. Holden Chow. Thank you, Chairman. I welcome this change from the Legal Aid Department. At this panel, many members have raised these points. We need to put things right again. In 2019, there was black-clad violence. There were black sheep in the legal sector. They colluded with the rioters. They incited illegal behavior. Things went wrong, so those from the legal sector helped them. They showed them how to apply for legal aid. That happened in the past. There were loopholes. If we leave those loopholes be, then we are being irresponsible. That's why members raised these concerns. There were changes to the legal aid system. Ms. Carmen Khan made a great point. The last sentence in that paragraph in the paper, this change needs to make one point clear. For criminal cases, the legally aided person will be assigned a lawyer. That's what the system is meant to be. The applicant does not get to pick a particular lawyer. There may have been a public misconception, but now we're putting things right again. Now we have seen the enhancement measures to legal aid systems. I welcome these changes. Now we have talked about criminal cases. Now I turn to judicial reviews. We have seen cases of abuse. No matter how good a system is, abuses happen. So there is a cap on the cases lawyers can take up. I see a drop in the cases going to lawyers. So now we see the cases spreading out to different lawyers instead of having an over-concentration of cases in the hands of a few lawyers. So my question for the legal aid department is, over the past year or two, what are the figures for judicial reviews? I know some cases involve the bogus claimants or bogus refugees. Apart from cases involving bogus refugees, what are the figures like for the other judicial review cases? Can we have those figures? Thank you.
Director, please. Thank you, Mr. Chow, for the question. I'll give you some figures over the past few years. In terms of legal aid certificates, well, Law Society's representatives also mentioned such figures. The number ranges from 3,000 to 5,000 in terms of approved certificates. As for 2022, there were 93 certificates. In 2021, 84, and 2020, 82. And these cases involve bogus refugees, or what I should put as non-refoulement claimants. For other judicial review cases, for instance, if an applicant wants to challenge the government's decision of expelling them from their residence, for these legal aid cases, the certificates we approve is about 10 odd certificates. So it is less than 1% of the total number of certificates we issue. So please be rest assured that we are not spending a lot of resources on JR cases. On allocation of resources over the past few years, the money we spend on JR cases is less than 3%, and most of the resources are allocated to divorce cases or work injury cases, etc. Next, Ms. Doreen Kong. Thank you, Chair. Well, Mr. Hong mentioned that he wanted to have more communication with the government in relation to legal aid cases. I understand that the legal aid department can perhaps have more communication with the Law Society to regularize the communication with them on the discussion of cases. Also, it is mentioned in paragraph 12 of the government's paper that the department wants to raise public awareness or dispel misconception of the department by the members of general public. I think most of the citizens, they are aware of the existence of the legal aid department, but they may not have a lot of information about the department. I wonder if the department will conduct or carry out any activities to raise public awareness on legal aid. In paragraph 14 of the paper, it is mentioned that three solicitors and one counsel have reported and returned the papers under the new duty imposed. I want to know if it involves any wrongdoings of the lawyer's part and whether there were any punishments on them in these situations. Thank you. on and stepping up publicity in the community, all along our department has, with various stakeholders, communicating about our work. We have talked to NGOs and labor unions and explained to them about our work. Every year we meet with the FTU for 3 to 4 times in relation to our work on work injury cases. And we also work with RTHK, and we produced a series of 6 episodes of programs to introduce to the public about the work and operation of the Legal Aid Department. We will continue to strengthen our publicity effort and take the initiative to do different work. For instance, we will invite secondary school students to our department, and we will give talks to them. A lot of times it's usually the schools that approach us, but now we will take the initiative to extend our invitations to schools. And for regular effort on publicity, we will keep up with the effort. Your second question is about the mechanism. Sorry. I asked about your communication or regular communication with the Law Society. Our department sends representatives to meetings of, say, civil case committees, etc. A lot of times, we send representatives from departments to, say, civil court user committees and other committees that are of concern of members of the legal profession. I wonder if you can step up communication with the Law Society. There are channels for us to communicate with the Hong Kong Bar Association as well as the Law Society. There is the Legal Aid Committee and there is the Work Injury Committee, and members of these committees have regular meetings with us. And due to the epidemic, we reduced the frequency of the meetings, but moving forward, we will resume meetings with these committees. These are non-official meetings. For official or formal meetings, we also discuss issues that are of our concerns. Thank you, Chair. I hope that you will step up communication with them. I understand that the Family Law Committee wants to have discussions with your department as well. Mr. Dennis Leung. There were misconceptions from the general public in relation to the legal aid system. People thought that they were able to nominate their own lawyers. In the past, there were cases of champity and also issues arising from permission to legally aided persons to nominate their lawyers. And we talked to these aided persons and they told us that someone gave them the name cards, and then the aided persons were asked to contact these lawyers. But in fact, these people are not lawyers. They are agencies that helped aided persons to deal with legal matters. And oftentimes these victims or aided persons are unable to recover the money they paid or they had paid to these agencies. I think we need to rectify these problems, and the government has to improve the system. The government has to do more explanation work. For those who are unable to afford their own lawyers, the government's legal aid system can really help these people who are unfamiliar with the legal proceedings or legal procedures and help them fight for their own rights. The question lies in how the government can serve as the gatekeeper. When the department approves legal aid applications, perhaps the government can do more to check whether the lawyer assigned is competent. And with these works in place, what is the workload of the legal aid department like? Does the legal aid department have the resources to implement all these enhancement measures without undermining the interests or rights of the legally aided persons? I'll ask Director to respond to the question, and perhaps Deputy Director can respond to the question about agencies. Sorry, Director of Legal Aid first. Thank you, Chair. Ms. Chen also mentioned about issues in relation to champity. Our department has done work to try to improve the situation. In 2013, we introduced the declaration system. That is, when legally aided persons are granted legal aid, they have to make the declaration. When they nominate a certain lawyer, it has to be done on his or her own volition. And the decision made cannot be interfered by anyone. So we ask them not to listen to anyone who encouraged them to nominate a particular lawyer. And after the aided person is granted the legal aid application, anyone that approaches them claiming that they can offer help to the aided persons, they should report it to our department immediately so that we can be aware of any cases of champity. We have talked to the two legal professional bodies to see whether we can minimize such situations. If there are lawyers who are involved in activities of champity or touting, then we can, in accordance with the established mechanism, conduct investigation or remove the lawyers concerned from the legal aid panel. We hope that these measures can help address the issues of champity. Member also asked about whether we are seeing an increase in our workload after implementing the enhancement measures. The answer is yes, but we continue to keep in view the workload of our colleagues to see whether it has reached an unacceptable level. If that's the case, we will, through internal deployment of resources to remedy the situation or apply for additional manpower if needed. Next, Mr. Paul Che. I think we need to adopt a balanced approach. Say if you go to see a doctor, they don't usually get to choose their own doctors. And this is a consideration that we have to take into account when we implement a public policy. Hopefully, for those who lack the experiences, we can also allow these lawyers to take up legal aid cases. Sometimes, or in some cases, aided persons want to nominate a lawyer they are familiar with. So how do we ensure fairness? We need to adopt a balanced approach. Director mentioned about dealing with cases in a case-by-case basis. I wonder if there are any guidelines within your department that set out the criteria for you to approve legal aid applications. Just to give you an example, for the 35 plus cases, it is now being tried in court. Everyone in the court was or is local, but because there is one foreign lawyer, then the case has to be conducted in English, and a lot of resources has to be devoted in it. Do you take the amount of resources you have into consideration when you approve a legal aid application? Is that an appropriate consideration? I'm just wondering if you have any guideline in place.
Now, my second point on lawyers who are considered not suitable. I've received complaint. I believe I'm one of the victims. I want to declare my interest. I'm a panel lawyer with a legal aid department. Now, in fact, in quite a number of cases, I've heard that I have been described as being not suitable. There's bad mouthing. What are some ways I can appeal? Some criticism may be fair, others less than fair. Are there mechanisms for lawyers who are described as unsuitable? Or is it a case where an applicant says a lawyer is not suitable and then the panel lawyer doesn't get to take up the case? Now, with the consumption voucher, there's a review mechanism. So for the LAD's panel lawyers, is there a mechanism for a solicitor or a barrister affected to apply for a review? Can we have something like a panel with 2 or 3 people sitting on it? Is there a review mechanism to ensure fairness? Now, let me quickly get to my third point. The government said after getting the consent, there would be further communications. But I'm not aware of any recent years of communication. Is this still under preparation? Or is it something you're working on? A brief reply, please. First, on assigning lawyers, we have criteria that we go by. We have a menu. Lawyers have access to them. The menu is actually online. Mr. Te can also refer to the information. The language in a trial is one of the factors we consider as we assign lawyers. Now, Mr. Te referred to one particular case. I'm not in a position to comment on that particular case. But then the language in a trial is one of the factors we consider in assigning lawyers. Now, on review mechanisms for solicitors or barristers affected. I'm sorry, on that point, we put the interests of an aided person first. Say a lawyer has a poor track record, or a lawyer was subject to disciplinary actions from a professional body. We let the aided person know such history, and then we get the applicant to consider whether to nominate that lawyer. We've seen cases where the applicant knew about the track record but went ahead to nominate that lawyer. We want to avoid delays. If we get another mechanism to look at the selection process, that may not be the appropriate way to go. After all, we want to put the interests of the aided person first. Now, on the point about the consent, for judicial reviews, we get the consent of the aided person. When we consider it necessary and appropriate, we will make public the reasons for legal aid applications in judicial reviews. We ask the applicants to sign the consent. That's an internal process. We don't see a real need to widely publicize this measure. Thank you. 3 members will speak for the first round and another member speaking for the second round. If no other members press the button, and I will draw the line here. Now it's 6:05 now, so I will draw the line here. Mr. Ambrose Lam, Chairman. Last year, I received comments on fees. The legal aid departments offered low fees, and then after the cases wrapped up, payment was slow. This year, I haven't received any complaints, so that may be a sign of improvement. After a case is concluded, the lawyer sends over the invoice, and then the legal aid department haggles with the lawyer over the fees. The legal aid department offers an outrageously low fee, such that it's like an insult. If a lawyer overcharges, the legal aid department can lodge a complaint with the Law Society. Make an example of that. That's how we can establish mutual trust. A lawyer quotes a fee and then the legal aid department pays, and that will help speed up the process. Now, we cannot just pay what's on the invoice issued by each lawyer. We go by the ordinance. We go by the costs taxed by the court. Now, we go by a fee that's no more than 75% of the total fee, and then the remainder will be paid after the case wrapped up. I thank Mr. Lam for his suggestion. So if a lawyer overcharges, we will let the Law Society know. We will consider this suggestion. Ms. Eunice Young. Now we're talking about the situation after the enhancement measures were put in place. Over the past couple of years, in 2021, in civil cases, we have 11,000 cases or so, and then a year later, we had 9,000 cases or so. So on civil cases, we've improved the legal system, and there are fewer legal aid cases. Does it mean the measures are effective? Or what does the government make of the decrease? It's a drop by 2,000 cases or so. Has the government assessed why there's a drop in the number of legal aid applications? Is it because people are getting their own lawyers, or they're using other options as a result of not being able to pick their own lawyers? Or is it because there are fewer cases? That's my first question. Now, on cases assigned to other lawyers. Now, I haven't taken up any cases from the LAD. Say you assign cases to lawyers. For lawyers with an experience less than 3 years, only 1 lawyer got cases. For 3 to 5 years of experience, 15 cases, or rather 15 lawyers had 1 to 4 cases. Now, for 6 to 10 years of experience, 44 lawyers had 1 to 4 cases. For those with experience over 10 years, now 226 lawyers, or rather barristers, had 1 to 4 cases. So for those with experience of more than 10 years, those barristers are more likely to get cases. For those with 3 to 5 or 6 to 10 years of experience, fewer such barristers get cases. Now you have a panel of lawyers. What are the criteria the government goes by in assigning cases? Will the government favor the more experienced lawyers? Or will the relatively inexperienced lawyers also get to take up legal aid cases? Now I want to write on this point. This is a question I have in mind too. In terms of the years of experience, the legal aid department is only looking for those with 3 or more years of experience. For legal aid cases, 3 years of experience. So how come we're seeing more experienced lawyers getting more cases? Will the government consider assigning more cases to barristers with fewer years of experience? I believe this is in the same vein as a question from Mr. Paul Tse just then. And that's also my question. I thank the member for her question. First, on the drop in the number of applications for legal aid, we have assessed the situation internally. I believe that has nothing to do with the enhancement measures. Over the past couple of years, we've had COVID. Unless those were urgent cases, the applicants would delay the application. Say, with matrimonial causes, quite a number of applicants were in the mainland. There was COVID. There were disruptions to cross-boundary travel. The applicants could not make it to the office to file an application. During COVID, there were control measures, so we had special work arrangements. So we were at a reduced capacity in dealing with applications. We believe that's the reason behind the drop in applications. In terms of the approval percentage, it's somewhere about 40%. We believe the drop has more to do with COVID than anything else. Now, on assigning cases, we have a set of criteria to go by. The lawyer has to have at least 3 years of experience. Three years of experience is still kind of junior. As I said, when we assign cases, we put the interests of the aided persons first. Experience shows that we assign cases to lawyers with some years of experience. That will assure us that these are experienced lawyers who can safeguard the interests of aided persons. For 80 to 90% of cases assigned, the cases go to lawyers with 10 or more years of experience. Now, for someone who has met the 3-year requirement, we do assign cases to such solicitors or barristers. Sometimes you may have a complex case that requires a senior counsel. In that case, we can have a senior counsel leading a junior counsel, sometimes even with less than 3 years of experience. But the minimum requirement is 3 years of experience. For cases at higher levels of court, say the High Court, the Court of Appeal, we may assign a case to a lawyer with 5 or 7 years of experience. Again, this is all about the interest of the aided person. If something goes wrong due to the inexperience of the lawyer, then that would be a bad thing for the aided person. That's exactly where I don't think it's right. The interest of the aided person should not be the sole consideration. Just then, Mr. Paul Tse gave you an analogy of doctors. Every patient wants the best doctor, but that does not mean you can always get the best doctor for each patient. I believe you are not getting the balance right. The aided person's interest, resources, and also the interest of the legal profession. You have failed to give due consideration to all these factors, and you need to reconsider this.
Now it's my turn. It is mentioned in the paper that if lawyers fail to meet or comply with the requirement of reporting in writing and returning the papers immediately if it is foreseeable that they will not be able to perform their duties, their names will be removed from the legal aid panel. Well, according to the legal aid department, it is asked that the lawyers should not have any records of poor performance. Does that mean those with record of unsatisfactory performance, they will be removed from the legal aid panel, and that their name will not appear on the panel in the future? For panel lawyers with record of unsatisfactory performance, they will still get the chance to be assigned cases unless their performance was so unsatisfactory that we decide to remove his or her name from the panel permanently. If the panel lawyer only has a record of unsatisfactory performance, he or she will still be assigned cases. Say a legally aided person nominates a lawyer, and the lawyer he or she nominates has a poor record of performance, then we'll explain the situation to the aided person. And if the aided person decides to nominate another lawyer, then the question is solved. However, if the aided person insists on nominating that particular lawyer, then we will decide whether the record of unsatisfactory performance of the lawyer has anything to do with the case or will affect the case concerned, and whether it will, or whether the record will undermine the interests of the legally aided person. If we, after making the consideration, is of the view that the poor record will not affect the interests of the legally aided person, then we will approve the nomination. If we think that the aided person's interest will be undermined because of the record of poor performance of the lawyer nominated, we will explain the situation to the aided person. And if the aided person does not agree with our suggestions, then they can appeal to the higher court, and we will decide whether we will go along with the aided person's decisions. Well, I think it's now Ms. Maggie Chan's turn, and your questions were not addressed in the first round. Is that right? I want to ask about the nomination mechanism for civil cases. Yes, please ask your question. My question for the director is this. I give my support to the enhancement measures. I hope that every year you'll come to the council to update us on the implementation of these measures. I have a question about the nomination mechanism for civil cases. I understand that there are certain requirements or criteria that you have to fulfill. Aided persons, when they want to nominate a lawyer, they have to fill out a form, and your frontline staff do a lot of explanation to them. Well, without a guideline, how are you going to explain to the aided persons about the form? I got complaints that you have wrong explanations about the lawyers on your panel. I hope that there can be a more complete mechanism in place in relation to the nomination of lawyers for civil cases. Director. One mentioned that we give advice to applicants or aided persons, and some lawyers may be of the view that we are bad-mouthing them. Members of the legal profession sometimes write to us and make complaints and ask why we make certain comments on them to the applicants, and we conduct investigations when we receive complaints like these, and we will see if our staff actually give improper comments or appropriate advice to applicants or aided persons. If after the aided persons have listened to our comments on a particular lawyer and he or she insists on nominating a particular lawyer, and if our comments do not align with their wish, they can appeal to the registrar or make complaints to us. If they are not able to be assigned a lawyer they want, they can make complaints. Chair, one quick follow-up question. I think what the director suggested is not really a people-centric approach. I have a suggestion. When an applicant makes a nomination, anything suggested by your frontline staff should be recorded, so that we can refer to the records when there are complaints. Thank you for your comment. We keep records of every interview between our staff and the applicants. When there are complaints, we check the records. If there is a lack of record, we also ask our staff and the applicant or aided persons to give a statement to help us with the investigation. That's all for this item. Thank you, government officials, for attending this meeting, and I also would like to thank representative of the Law Society for attending the meeting. Chair, one quick question. If the Legal Aid Department is not entertaining applicants' nomination for lawyers for criminal cases, should this part be scrapped from the application form? I think the Legal Aid Department should make it clear. Thank you, Mr. Hong. We no longer provide application forms to legally aided persons to prevent them from nominating lawyers in criminal cases. Also, when we assign lawyers to aided persons in criminal cases, we take into consideration a host of factors. If a lawyer has represented a legally aided person at the lower court level, and when the case reaches a higher court level, we will, from the perspective of saving public funds and also from the perspective of the aided person's interests, decide whether we should assign the same panel lawyer to the applicant. Sorry, I'm afraid that you cannot have direct conversation like this in this meeting room. You have to, through the chairman, discuss the matter if you wish to, and we have wrapped up this discussion item already, and I will not resume this item. There being no other business, meeting adjourned. Thank you.